All rise. Vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
An accused is presumed innocent, and it's not detention, house detention. Article 63 did not have that purpose. So, Your Honours, what we've said very plainly is that in the unique circumstance of the present case, when Mr. Ruto not only is an individual voluntarily submitting to the jurisdiction of this court and literally bowing to justice, he is also the Deputy Head of State of the Republic of Kenya, a state party, with unique responsibilities, with a mandate, of course, from the Kenyan people, and bound by an oath of office to the Constitution. What then should be the state of play? We say that a proper interpretation of Article 63 requires that presence of the accused is met by his willingness to cooperate with the court, his surrender to the jurisdiction whenever it is required, and at critical stages, we've said opening, closing, judgment, and whenever the bench decide. And at other times, representation is met, presence is met by presence through counsel. Now, Your Honours, this is not a novel proposition in our view, because the reason in our submission that the drafters of the statute required presence was not as a punishment but an expression of right, in particular to draw a clear line between the system in this court and the civil law particularly, or the STL now, the Special Tribunal for Lebanon, which allows trials in absentia. Contrary to what my learned friends for the victims and others say, we're not requesting trial in absentia. Mr. Ruto voluntarily showed respect to this court and voluntarily came and cooperated, in fact, even with the prosecution, before a summons was even issued. He did it after the summons was issued, before confirmation, after confirmation, and res ipsa loquitur. He's here today. Your Honours, what we're saying is that properly meets the concerns of the international community, it meets the requirements of the Rome Statute, that he can exercise that right in a manner that balances these competing demands, his personal conviction and respect for the court, and his constitutional duties. But, Your Honours, we do say that the prosecution approach to disclosure is deficient, it's disorganized, but it's also tactical. And it's shown both at the confirmation stage, it's shown now, that we're dumped at the last minute with evidence. And even now, we don't have the complete evidence. Your Honours, we are concerned in this case about issues to deal with bribery, inducements, anything that could impinge upon the real veracity of witnesses that will come before you. This court has an important mandate. This is why Mr. Ruto is here. And this court, the international community, and the Assembly of State Parties deserves better, a better quality of justice than we're getting from the prosecution. And Your Honours are going to be circumscribed in getting to the truth unless we're given an opportunity, we're given the adequate time and facilities. Your Honours, I have the immense privilege of, with my learned friend Mr. Hooper and the rest of the team, of representing Mr. Ruto. He's done whatever he can do to get adequate facilities in place. But what we are doing is coming to the bench and saying, trust us as experienced counsel when we say we need additional time. We have the right to adequate time and facilities. The facilities have been provided. We're working as hard as we can work, 7 days a week, literally. But we need time. And if we don't get time, justice will be in peril in this case. Your Honours, when there's been no fault of the defence, that is something that should abhor all right-minded people. And Your Honours, we're confident that when you consider this matter, you will grant the additional time needed. Your Honour, those are my submissions, unless I can assist further. I'm grateful.
The intention of our client is to be available in court throughout. Your Honor, may I go on that issue? However, if an order is made that there is an option for an accused to participate without necessarily being physically present, we would assume that that order would not be conditional. It would not necessarily be saying only the first accused. And so we will wish to avail ourselves that option if it is made. The volume of the material given to us, and Madam President, we have over 11,000 pages to read. We have over 41 witnesses to deal with. We have over 980 documents to read. And the disclosure still goes on. In view of all those circumstances, the rights of the second accused, Mr. Joshua Sang, to a fair trial would be compromised if he is not given enough time to analyze, study, and respond to what the prosecution have said. And we pray, Madam President and Your Honours, that you allow us to commence this hearing in November, and that you put an absolute ceiling on the prosecution's disclosure timetable. Madam President and Your Honours, we also pray that you do in your decision make observation as to whether the prosecution should be allowed to do investigations forever. Because every other new day they say they have discovered something new. Every other day one of their witnesses is changing his mind, wants to add a statement. And we pray that there be a line from which we can start responding to their case, which keeps mutating and keeps changing. For all those reasons, Madam President and Your Honours, we pray that you find us deserving of the exercise of your discretion to extend the time at which this trial could commence to the month of November, and that the prosecution's disclosure regime and investigation be put to an end at a given time in the exercise of your discretion. Thank you, Madam President and Your Honours.
Your Honour, Madam President, Your Honours, it is the prosecution's view that these are very serious crimes that deserve serious attention, and they require the physical presence of the accused at trial. Our argument is based on, of course, Article 63 itself, the plain reading of the statute, which says that the accused shall be present. It does not say that he be present by video link. It does not say that he be present sometimes and excuse himself from the substantive portions of the case in chief as well as the defense case. Our argument also takes into consideration a holistic view of the statute. What we mean by that is that the waiver of the accused's rights at confirmation is expressly allowed, and it's expressly allowed in Article 61. Turning to the argument that the accused makes that attendance by video link would be okay, we again believe that Article 58 contemplated video link. The drafters, the framers, saw that as an option, but did not include it in Article 63, and again, required that the accused be present, physically present. Article 63(2) contains one limited exception to that rule, which is when the accused is continuously disruptive. And it presumes, of course, that the accused is present. That's not what the defense is asking for here, and his prayer is not covered by this exception. We believe that witnesses will be brought before you. They need to be reassured that there are people that are listening, and what they have to say counts, it matters, and it will be heard. not only by your honors, but by the parties that are present. Also, the prosecution's view is supported by the fact that the victims need confidence in the system. They too need to feel as if they are being heard, not only by your honors, but by the parties. But most importantly, Madam President, your honors, is that the public, in our view, needs to know that we have confidence in the judicial system here. They have to believe that the process works. And seeing the accused present reassures them that that is indeed true. We would ask that a fixed date be set. We believe that's important to have a certainty and to have something to strive for. We recognize that the Regulation 35 applications remain pending with your honors and that a decision on them is forthcoming. That needs to be considered into the scheduling of trial. However, with that said, we also believe that the security situation and the special circumstances surrounding this case should also be considered. And balancing those, we believe that a trial date of November would be excessive. Your Honor, if I may, I move on to disclosure. We, of course, disagree with Mr. Sang and Mr. Ruto's assertions about the prosecution's conduct in this case. So I will limit these submissions to simply what is the question before us today, which is, what have we disclosed thus far and when? And also what is left to be disclosed so that we can set an appropriate date. We'd like to assure Madam President and your honors that the prosecution has acted diligently. It reviewed its materials before confirmation hearing and made the appropriate disclosure to the defense. After the confirmation hearing, the prosecution continued to review its collection and provided further information to the defense. There was no wasted year, as earlier referred to. However, Madam President, we acknowledge that the system is not perfect, it's human, and it's fallible. And oversights have been made, and we owned up to those oversights in filing 715. We also have re-reviewed materials as we've gone along, and when potentially exonerating information or Rule 77 information arose, we promptly gave it to the defense. Now, they have cast or asserted that there have been over 100 violations here, and we disagree with that.
When you say as soon as possible, do you have any specific date in mind or just as soon as possible?
As soon as practicable, Your Honor. What I will say is that I think the setting of the trial date does depend on the decision on the Reg 35s. I think that's a fair statement. And security measures do have to be put in place for any new witnesses should they be allowed. And that does take some time. That's, again, implemented by VWU, and I can't speak to how long that would take. But that would be a consideration. With all of that said, yes, as soon as practicable.
So your submission is aside those recent Rule 35 submissions, the prosecution is ready to start immediately, aside from Regulation 35.
Exactly.
Thank you very much.
Madam President, Your Honors, for good record and for the avoidance of any doubt, I want to set the record that I have cooperated with the Office of the Prosecutor before even summons were issued, I have submitted to the jurisdiction of this court when required, and will, without any fear of contradiction, do so in the future. This is because I firmly believe in my innocence, and secondly, that I believe in the rule of law. Your Honors, I am acutely aware of my civic duties and my obligations to this court. That is why voluntarily I will continue to cooperate with the court the same way my country, Kenya, voluntarily became a signatory to the Rome Statute and thereby become a member state. In pursuit of that constitutional obligation by Kenya, I am aware that my responsibilities to the court as an individual must be balanced by my constitutional responsibilities as Deputy President of the Republic of Kenya. I am acutely aware. Two further issues, Your Honors, that are very passionate to my heart is the circumstances that are surrounding this matter that produced two sets of victims, which I'm very passionate about. The post-election violence victims whose lives and property were destroyed and deserve justice and truth. And another set of victims which I belong to, victims of a syndicate of falsehood and a conspiracy of lies choreographed by networks that are obviously against truth and justice. But I want to take this opportunity, Your Honors, in conclusion, to say that at a personal level, I will do my best, and at an official level as Deputy President of the Republic of Kenya, that the new administration, popularly elected by the people of Kenya in free, democratic, and fair elections, will cooperate with the court, because the President of Kenya and myself believe in the rule of law, and we believe that justice and truth must finally be found.